The case rose on an appeal to the Ninth Circuit Court of Appeals, where the legal questions became even more complex. Could the court compel a company to provide an experimental drug? Did the promise form a legally binding contract? And did this obligation interfere with the FDA's authority? The Ninth Circuit had a choice to make, and their decision would ripple beyond just these patients. It would clarify something essential in the world of law. Exactly when does just a promise become a contract? Now, close your eyes. Visualize yourself outside the courthouse, and let's find out what happened on the fateful day of October 13th, 1993, inside the United States Court of Appeals for the Ninth Circuit. The courtroom was still. Not a large room, not one filled with news cameras or reporters, but a modest federal courtroom in the Ninth Circuit, where law, not spectacle, commands the floor. A wooden bench, a carved seal on the wall, 3 judges seated high above, robes, solemn faces, gentle curiosity in their eyes, and beneath them, 2 very different sides. On one side, the patients, led by Dr. Christina Dahl, who sat calmly, wrapped in a soft sweater, her eyes heavy with fatigue. Not just the fatigue of her condition, but the deeper exhaustion that comes from fighting for something that once seemed promised. On the other side, Pharmaceuticals, a small biotech company, once hopeful, now defensive. Their counsel straightened his tie and looked toward the bench. The stakes were clear, not just for Christina Dahl, not just for Pharma, but for what it meant to form a promise and have it mean something.